Okay, so this is United States of America versus Sean Diddy Combs, and this is the defendant's Sean Combs motion to exclude Rule 413 and 404B evidence. This is his lawyers wanting to exclude evidence from the trial. Okay, introduction. I got really sick. It was like 70 degrees out, and then it started raining one day yesterday, and I took the dog out. I didn't have a hat on. It was cold raining, and last night I started getting sick again, so I'm back to being sick. This weather screwed up. Then it was snowing this morning. Okay, so introduction. After months of refusing to disclose the identity of alleged victims, and just 60 days before trial, the government suddenly announced that it intended to show its case with evidence of blank, undercharged and uncorroborated crimes, including blank, purported incidents of sexual assault, all but one of which supposedly occurred decades ago. The incendiary alleged allegations are substantially more serious than the charged offenses, and it admitted would make it impossible for Mr. Combs to receive a fair trial. This is his lawyers. This is like, what, 39 pages? 99 pages. I don't know. For example, the indictment does not allege blank. Instead, the charges focus on alleges and domestic abuse of supposed economic coercion of longtime girlfriends. So, girlfriends, not just one. Now, we know from the other court documents from the other day that I read that Cassie is going under her name. She's going to testify under her name. So what other girlfriends has he had that's coming out? Is it Young Miami? That if the case, Mr. Combs has been defending for months, yet now, of the eve of the trial, are more the superseding indictment, the government has surfaced a new plan to taint his trial with evidence about purported heinous acts, blank, including allegations of blank. They are entirely new, untested, uncollaborated, and uninvestigated allegations. All but one of the indictments happened over 20 years ago, with the oldest dating back to the 1980s. So they're not prepared for trial. They're not prepared for trial. The court should require the government to try the case if charged and prove that the case to the jury beyond a reasonable doubt. The government should not be permitted to pollute the trial with decades of dirt and uninvite a conviction based on potentiality evidence with no proper purpose by painting Mr. Combs as a bad guy. Yeah. Who must have committed the charged crimes. The evidence of alleged undercharged sexual assaults must be excluded. Do you hear this? Under the federal rule of evidence for multiple reasons. The evidence is not admissible under law 413. So that's what they're asking for, rule 413. Because Mr. Combs is not formally charged with the crimes of sexual assault. Yes, he is. Yes, he is. I read you the document the other day. I read you that in the superseding indictment, they were charging him with that. Yes, they were. So here's their evidence here, right? So all this is exhibits A through G, and it's under seal, so that there's not going to be opened until trial. And so here, so there's been a lot of stuff. Just today's the 7th, so you got 4 things that have been leaked today. And you can see this got 1, this got 1, this got 2, and this got 1. This one you have to buy. But he was charged with his superseding indictment, which was up here, right here. He was charged with it, right? Count 1, racketeering, right? Count 2, sex trafficking by force, fraud, or coercion. What's this? Count 4, sex trafficking, right? Count 3, transportation to engage in prostitution. So I guess not. Sex trafficking by force or coercion. Count 5, transportation to engage in prostitution. So he wasn't. So is there going to be another indictment coming out charging him with rape? Okay. I think this is the one we're reading. Oh, this is part 2. This is 2-page. See, they want to. Now these are exhibits that we can't see right yet. Attached here is Exhibit C, the photograph of a newspaper clipping. We can go back and find that stuff if we wanted to. So this is where we were. So though he wasn't, we'd have to go back to the original. We would have to go back to the original document, right, to see. But the court should require the government to try the case if charged and prove the case to the jury beyond a reasonable doubt. So they're probably going to charge him with sexual assault. If you want me to leave these documents in there, I will. Like, as you can see, I'm still sick. Like I said, I walked a dog yesterday, and it was like 70 the day before. So, and it was lightly drizzling, and I didn't have a hat on. My coat was open, and it was cold. And then last night it just started to hit me. And so today I've been laying down all day. The skank discovery the defense has received regarding any of these incidents came long after the government's December 31st, 2024 deadline. The government apparently and troubly plans to rely on trial on the alleged victims' uncorroborated allegations alone. Well, you're failing to realize they have that tape. They have a lot of tapes, don't they? But they have that Kathy tape from when he drug her down the hallway. What do you think he was doing? That there proves kidnapping. The motion primarily addresses the alleged sexual assault notice in the government's letter. The last two acts noticed in the letter do not implicate Rule 4.1. Okay, 404. So they want them to exclude this evidence because it wasn't admitted as in the documents, the original documents, and they had to December to put this in. So they're pleading against it. Are they going to get it? I don't know. And here's the exhibits that they were talking about, see? And they're under seal. I'll put this letter in here. So this is the counter act. The government. This is the Matthew Pulaski, acting United States Attorney, Southern District of New York, 26 Federal Plaza. And they list all the attorneys that are representing this. So this is the attorneys. This is the government. Memorandum of law in opposition to the defense motion to Lyman to pre-collude evidence pursuant to Rules 415 and 404. So this is the government's response. This is the DA's response to allow this into evidence. Okay? Are they going to be granted? Let's see what they say. The government respectfully submits its memorandum in opposition to the defendant's motion to Lyman to exclude evidence of the defendant's sexual abuse of other victims under Federal Rule Evidence 413 and 404B. Since the arrest, the defendant has insisted that every victim in the case consented to every sex act. I'm so terrible. The defendants have put his knowledge and intent squarely at issue. To resolve the dispute, the jury is entitled to hear the testimony of blank. The testimony powerfully establishes that the defendant made no mistake when he coerced other victims into unwanted sex. It proves that the defendant intended to take the sexual gratification he wanted regardless of consent. So remember, Diddy and his lawyers were sitting there saying that all the sex acts were consensual. Well, this is stating that it wasn't. Certain of the evidence is admissible as direct evidence of count 1 and should be admitted on that basis. Further, the court should admit the evidence both on evidence of other sexual assaults under Rule 413 and the evidence of the defendant's knowledge background. The charge of evidence against the defendant, March 6, 2025. The grand jury returned indictment. There's the indictment charges. Charging the defendant on 3 counts, racketeering, conspiracy, in violation of this U.S. 18 U.S.C. Count 1, sex trafficking in violation of 18 U.S.C. 2, count 2, and 3, interstate transportation to engage in prostitution. So what our government is now doing is, you transport any sex worker, even, they're a sex worker, they're a prostitute or whatever, or stripper, whatever, they go across a straight state line, they are sex trafficked, okay? So I wouldn't give nobody a ride no more. That's for one thing. No more hitchhiking, no picking up strangers, giving nobody a ride. Assisted by the other members of the Association of the Racketeering Enterprise, the enterprise engaged in numerous offenses constituting racketeering activity, including irrelevant here sex trafficking, forced labor, and other acts of sexual and physical violence and obstruction. Count 1 alleges, as part of the pattern of racketeering activity and defendant sex trafficked 3 victims, victim 1, victim 2, and victim 3, through force, fraud, and coercion. So even though Diddy's lawyers put out that they want to exclude the new superseding indictment for rape and all this, the government has just submitted its plea to the judge for them to allow. Now, will the judge submit it? We'll have to look. And you can see all this is retracted. Look at all this retracted stuff. Look at all this retraction. Now you see why I just speed right through it. Look at it. The court should admit evidence on the defendant's other sexual assaults as direct evidence, and in the alternative, under Federal Rules of Evidence 413 and 404, evidence that the defendant's sexual assaults of blank is admissible as direct evidence of, among other things, the existence and purpose of the charge, enterprise. Notice how they keep enterprise? Enhancing the power of the defendant through sexual abuse, and enabling the defendant and other members of the association of the enterprise to engage in. So it looks like other people are going to be brought into court that were in with Diddy abusing these people. It shows the pattern racketeering evidence which the defendant and other engaged involved in persistent and persuasive patterns of abuse towards women and other, including verbal, emotional, physical, and sexual abuse. So, is this going to be granted? We'll have to wait. For the foregoing reasons, the court should deny the defendant's motion to preclude evidence under Rule 413 victims and grant the government's motion to omit the testimony under the rule. So if you want this, I'll put it in the comment box. As you can still see, I am still sick. And there's a lot to read. And I am not feeling good.